A state Supreme Court backs a Gun Owners of America and Gun Owners Foundation lawsuit where they secured a temporary restraining order, a comprehensive TRO, in fact, in Oregon against their attempt to have, or to try to convince the sheeple to vote away their God-given rights. Rights that aren't given to us by government, nor can they be voted away by misinformed, pink-haired lefties. Let's talk about this. Before I jump into it, I want to thank the sponsor of the video, and that's TriStar Trading. TriStar Trading has a ton of cool shirts and sweatshirts, hoodies. Everybody always asks me about my camo whoopee, and that's where I get it, guys and gals. TriStar Trading. Link is in the description of every single video. They do the Guns and Gadgets shirts and patches, and they also have some cool stuff like slings and belts. A lot of stuff over there. Thanks to TriStar Trading for supporting this channel and being a really, really good friend to my family. Love y'all. All right, let's jump into this. I waited a couple days because I wanted the entire ruling, and I'm going to show it to you because I think what the judge says, the Supreme Court actually, I think what the Supreme Court says is important to note, especially for those who live in Oregon. There's hope. All right, on your screen here is the order. Now, this case is called Arnold v. Kotek now. When it was first filed, it was Arnold v. Kate Brown. Obviously, there's a different governor now. But you can see here on the screen that it is Gun Owners of America and Gun Owners Foundation versus all of the anti-gun, illegal, horrible-minded folks in Oregon. And this actually should be suing every person who voted for Measure 114 as well. Now we'll start out en banc, which means all the members of the state Supreme Court. Original proceeding in mandamus. On petition for a writ of mandamus filed January 13th of 2023, considered and under advisement on January 31st, 2023. Robert A. Koch, the Assistant Attorney General, Salem, filed the petition and memorandum of law for defendants' relators. Also on the petition and memorandum were Benjamin Gutman, Solicitor General, and Ellen F. Rosenblum, the Attorney General. Tyler D. Smith, Tyler Smith and Associates, P.C., Canby, filed the memorandum in opposition for plaintiffs' adverse parties. Also on the memorandum was Tony Aiello, Jr. of Canby. Per curiam. The petition for a writ of mandamus is denied without prejudice. The motion for stay is dismissed as moot without prejudice. Now, before I actually give you the verbiage of what these judges say, what they're doing, let's get you, it's a lot of legal jargon, right? And that's why you watch this channel, so I can decode this stuff for you. So last year, Measure 1114 was put on the ballot, and the government and the anti-gun groups were able to trick enough sheeple to vote away their rights. It passed very narrowly, but it passed nonetheless. And what Measure 114 does, three real big things. One is to create a permit to purchase scheme for firearms. Two is a magazine ban. You know, those high-capacity magazines, woo, they're so dangerous. And the third was to create a training program and a fee process for getting this permit to purchase. And right away, all the sheriffs were like, we can't do this. We're not even set up for this. GOA secured a temporary restraining order and an injunction, meaning that you can't enforce this law. Any agency in Oregon, it's stopped until this case can be heard on its merits, which is where we still are. Now, I've said it numerous times on this channel, no anti-gun politician likes to take an L, and the state wanted to appeal this to the state Supreme Court, trying to get the state Supreme Court to stay that temporary restraining order so that they can thus promulgate their tyranny on the population of Oregon. And this is where the wording I'm about to show you bears watching. Per curiam. In this proceeding, the state asks that we issue a writ of mandamus directing the trial court to vacate 2 preliminary orders entered in the declaratory judgment action. Collectively, these orders temporarily restrain and enjoin the state from enforcing, while the trial court action is ongoing, Ballot Measure 114, which was passed in 2022, which voters approved at the November 2022 general election. We deny the state's petition for a writ. Measure 114 makes several statutory changes pertaining to firearms. Simply summarized, it requires a permit to purchase a firearm. It requires completion of a criminal background check before a firearm may be purchased, acquired, delivered, or transferred. and imposes restrictions regarding large capacity magazines. After the election, plaintiffs filed the underlying declaratory judgment action against 3 state defendants, asserting that Measure 114 is unconstitutional under Article 1, Section 27 of the Oregon Constitution. Plaintiffs also sought preliminary relief, which the trial court granted in 2 orders. The first was a temporary restraining order that restrained the state from enforcing the permit to purchase requirement together with the background check requirement. By its terms, that order will remain in place until the state notifies the court that the permit to purchase requirement is ready to implement, at which point the court will hold a hearing within 10 days on plaintiff's motion for preliminary injunctive relief. The second was an order granting preliminary injunctive relief as to the large capacity magazine restrictions, enjoining the state from enforcing those restrictions until a full hearing is held on the plaintiff's complaint. The state now asks that we issue a writ of mandamus directing the trial court to vacate those 2 temporary and preliminary orders. After considering the current procedural posture of the underlying action, we decline to issue a writ. We emphasize that our decision has no bearing on the parties' respective positions as to any aspect of the underlying proceeding, including the merits of the plaintiff's complaint. Our decision today does not serve as a bar to any future challenge in this court or otherwise on appeal. Rather, at this juncture, and given our understanding that the trial court is proceeding as expeditiously as possible to resolve the issues that these parties have presented, we have determined that we should decline to exercise our mandamus discretion at this time. We recognize that the legal status of Measure 114 is of significant concern to many Oregonians. Of course, it is the role of the judicial branch of government to resolve disputes such as challenges to laws enacted by the legislative branch, which includes the people exercising their initiative power. That resolution is underway in the trial court. Our only determination today is that now is not an appropriate time to exercise our authority in mandamus in connection with the trial court's temporary and preliminary rulings. The petition for writ of mandamus is denied without prejudice. The motion for stay is dismissed as moot without prejudice. So this is good. This is a state Supreme Court in an anti-gun state that isn't buying the BS that typical anti-gun states do. What do I mean? Well, at the very entry level, there's a lawsuit filed against an unconstitutional gun grab law, right? That's what happened here. GOA filed a lawsuit, and GOA got a temporary restraining order and some injunctive relief, right? The law couldn't be enforced. Well, no anti-gun attorney, no anti-gun governor, politician, attorney general, none of them want to take a loss because that's what they campaigned on. They're being paid to violate people's rights, so they always appeal. And in most cases, look at New York, the Second Circuit. Every time the Second Circuit gets an appeal because New York has been kicked in the teeth with an unconstitutional law ruling, they always overrule and say, you guys keep, that's okay. Let them keep doing that law until the end of the trial itself. And you see that in the Ninth as well. The Ninth Circuit is, especially en banc, like they're undefeated. And it's like 51-0. Anytime a gun of perceived victory on the Second Amendment gets to them, they overrule it. So this Supreme Court in Oregon said, you know what? The trial court is doing things as fast as they can to get to the final, trial based off of the merits, and we're not going to butt in. This is the way it needs to be, and we see no reason for us to butt in. And it has all of the anti-gunners in Oregon like crying crazy. If you go on their Twitters, like I did last night, whoo, they're big upset. But that's good. That's really good because the Constitution won a little bit. And, we still have the fight to go. And thanks to GOA and Gun Owners Foundation and the attorneys that are doing this on the GOA side, fighting for people in Oregon, thank you for doing what you do because they were proven correct. They were proven right again. So I always say it in every video, guys. Support those who support you. If you want to join GOA, there's a link in the description of every video I do. I get nothing out of it. It just lets them know you came from here, and they give you a little bit of a discount based off of what type of membership you choose. And I always ask you, please, to donate that back, at least that, and then some. So good on GOA. I'm going to say it. They're kicking ass lately. Good job. And we haven't seen the end of this case, nor have we seen the end of what GOA plans on doing across this country. Guys and gals, until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. Let me know what you think about this decision. And if you haven't already, hit that subscribe button down below. Like the video, share it so more people see it. Break this anti-gun algorithm. And I'll see you all in the next one. Take care.